welcome once again, everyone, to the Legal Support Center for Advocates, Nassau Suffolk Law Services presentation on SSI/SSDI, Cessation and Overpayment, with John Batanchiev. I'm probably butchering his name. But I am Sharon Campos, Supervising Attorney of Volunteers and Community Projects. And before we get into the presentation, I'm just going to review a few things about Nassau Suffolk Law Services and a little housekeeping. So first, please everyone just keep your microphone muted during the presentation so we don't have any background noise. You can put any questions in the chat and we will address them throughout the presentation. You can also raise your hand if you think that it's a little bit more easier to ask the question by unmuting yourself. And we'll have a poll pretty soon, so we'll do that in a few minutes. And then at the very end, we're just going to have a survey about the presentation and also about other presentations you'd like to see in the future. So Nassau Suffolk Law Services is Long Island's largest legal services provider. We handle over 6,000 legal cases every year. We do direct representation, phone consultations, brief service, referrals. We have offices in Hempstead, Islandia, and Riverhead. And our staff include attorneys, paralegals, and social workers. And we also have partnerships with community agencies. Here's our office locations and phone numbers. And we have a variety of different units that handle a multitude of different areas of law, including domestic violence, child support, but that's only downward modifications. For the domestic violence unit, you have to get a referral from a domestic violence agency in Suffolk County. We have multiple disability and health related projects, including a unit that's specifically for HIV positive individuals. I don't know how the Planned Cancer Project is there. Unfortunately, we don't have that project anymore, so please cross that out. That was supposed to be deleted. We have a unit dedicated to persons who have severe mental health issues. We have ICANN, Advocates and Managed Long-Term Care, an Education and Disability Rights unit, our Disability Advocacy Project, which helps with SSD or disability appeals. And we have housing units in both counties to provide legal representation to tenants who are being evicted. We have our adult home project and also our foreclosure project. And then we also have our consumer debt unit, our veterans rights project, our reentry project for individuals who've been convicted of a crime, public benefits, senior citizen project, which is only in Nassau County. And then we have our pro bono projects in both counties that assist with individuals who are seeking a divorce or bankruptcy. And then we have our community legal help project, which is providing half-hour consultations in our local libraries. All of this information, more details about it, can be located on our website, which is nslawservices.org. Hannah, would you mind just putting that in the chat for me, please? The website, thank you. And then we have our Legal Support Center for Advocates. So we have Kathy Lucidi, who is the head of our Legal Support Center for Advocates. You want to say hi, Kathy? Hi, Kathy. And then myself, I'm the supervising attorney. We provide technical support to advocates, including legislative staff, social workers, outreach workers, medical personnel, guidance counselors, and we have attorneys who call as well. It's really about if someone has a client who has a specific issue and so you're interested in whether or not we handle that case or need information, then please give us a call and then we'll let you know if we can handle it or we have a referral or we can just give you some information on the problem. We do host community trainings like we're doing today. We anticipate in January, February, and March of next year to go back to our in-person trainings, which we did before COVID. We had in-person trainings that were several hours long. So we do anticipate doing that come this January, February, and March. So please be on the lookout for that. You can get the information in our emails, on our website, and by following us on social media. And the other thing that we're going to be doing in the future is we're planning to have bi-weekly, like half-hour sessions, where if you have a new advocate or you're also interested, we're going to go into a little bit more depth about what Nassau Suffolk Law Services does, have a specific unit who is highlighted for that meeting, and also about a little bit more about Legal Support Center for Advocates. So it's going to be like a question and answer type thing where you can actually get into more information, more detail about everything we do. And we do also publish newsletters, and we have our legal lessons that we send out monthly, which have advocate tips or upcoming trainings or clinics. So lots of information in there. And then I'm just going to do a quick poll here. And so if you just take a moment to answer that. So what type of advocate are you? And have you ever called the Legal Support Center for Advocates? Okay, give it another few seconds. Okay, so we'll just share the results. So we have about a few attorneys, a bunch of nonprofit employees with us today, social workers, a paralegal, government employees. So we have a wide variety of people with us today. So thank you so much for joining us. We hope you have, it's a valuable presentation. And have you ever called the Legal Support Center for Advocates? A bunch of people have not, so feel free to give us a call. We have our information right there. And just as a reminder, this is our phone number and extensions, 631-232-2400, and then myself and Kathy. That's only for advocates, not for clients. Clients need to go to the receptionist because we're not case handlers. Okay. And of course, just a note, what we're sharing today is legal information. It's not legal advice. We make every effort to keep our educational materials up to date. However, things do change, and legal advice does depend upon the specific facts of each situation. So the materials we're sharing with you today cannot replace the advice of competent legal counsel. So just always keep that in mind. And I'm going to pass it off to Supervising Attorney John Batanchiev, and I'll let him introduce himself. Thanks so much.
Thank you, Sharon. Welcome, everyone. My name is John Batanchiev, Supervising Attorney for Nassau Suffolk Law Services. I supervise 4 of our units in our Nassau office, the Mental Health Law Project, Veterans Rights Project, Public Benefits, and the Reentry Unit. So for today's session, we're going to go over basics of SSD and SSI, resource and income rules for those programs, as well as an overview of cessation and overpayments, and just the options that recipients have when they're facing those situations. So next slide. All right, first for SSD, payments are based on a person's earnings. It's an insurance program paid through your taxes when you're working, and so people will, if they become disabled, they're able to apply and qualify. Their benefits will be based off of their income, and there are no and it's not regarding income or resource eligibility criteria. It's just based on whether they've worked enough have enough work history and are deemed disabled to qualify. Next. SSI, on the other hand, which stands for Supplemental Security Income, is not based on someone's earnings. It's a needs-based public assistance program that does not, as I said, is not based off of someone's work history. The way that someone would qualify is they deemed disabled and are unable to work and have limited income and resources, or they're an individual 65 and older with limited income and resources. Next slide. And I just included here 2022's maximum monthly benefit chart for SSI. I should note that for SSD, the average monthly amount a claimant receives under that program is around $13.63 as of this year, I believe. So there's a big difference between what someone would get under SSD compared to SSI for this year. As you'll see, there's also in this chart, there's a SSP. And if you're not familiar with what that is, in New York State, a portion of the SSI, there's a federal portion of SSI, and then there's the state portion called SSP, which is only for New York State. And it's the criteria is based off of the person's living arrangement, and this just includes that in there. And the examples in this presentation are going to be based off of the 2022 monthly income if we're dealing with SSI. And then on the next slide is just the 2023's, which just recently came out. And actually, we just started getting clients, COLA adjustments for SSI. I just started getting those today. So those you should be having your clients probably will be getting those soon if they're on SSI. The next slide for that as well. And those are the adjustments. So then the adjustment is now going to be effective January 1st, 1914, in the situation where the SSI recipient is living alone or living with others. All right, next chart. All right, so resource limits. As I may have mentioned before, for SSD, there are no resource limits. So someone could have 50,000 or 50,000 in a bank account or $2 in the bank account. It wouldn't matter for eligibility for SSD. However, there is a resource limit for SSI recipients, and it's currently $2,000 for an individual and $3,000 for a couple. These amounts have been set for quite a while, about maybe a number of decades. And currently, there is a bill in the United States Senate that may change that. I checked it earlier this week. It hasn't moved, but maybe during the lame duck session, there is some action on it and it does get passed. So I just mentioned it here since it is a bipartisan bill that would increase the resource limits and adjust them to inflation, as well as some other adjustments of reforms to SSI. Okay, next. So since there's a resource limit, sometimes people will get money from like a settlement or whatever, or have just saved extra money, and they'll think they'll need to give it away. And if a recipient, claimant, SSI claimant gives away resources for less than the fair market value or for free, basically for nothing, then that will be treated as a resource transfer, which, and if there's a rebuttable presumption that if that's done, it's done for the purpose of becoming eligible or continuing eligibility for SSI. It can be rebutted by the claimant by proving convincing evidence that the resources were exclusively transferred for a reason other than that. But then the next slide, we'll talk about that if Social Security deems that to be, in fact, what happened, there was a resource transfer, it does cause some ineligibility. So you can go on the next slide. So a claimant, if they're deemed to have been transferred resources, they can be ineligible for SSI for up to 36 months. And the way they calculate that is by taking the amount that was transferred and dividing it by the federal benefit rate on the individual's living arrangement. And then you take that and you round that number down to the whole number, and that's the number of months of ineligibility. So in this example, Rosa Ruder transferred $7,500 as a gift to her daughter after winning a personal injury settlement, and Rosa's monthly SSI amount is $841. If you divide 7,500 by 841, you'll get, I think, 8.9. You round down to the nearest whole number, which is 8 months. So she would be ineligible for SSI for 8 months. Next slide. All right. SSD income rules. So really the main income rule for SSD is as long as they're not working above what's called substantial gainful activity, or SGA, they continue to be eligible for SSD. The 2022 SGA limit is 1350 for a non-blind individual, and it's 2260 for a statutorily blind individual, and the 2023 numbers are listed here as well. So as long as an SSDI claimant is if they're working and they're working below that SGA limit, there should be no impact on their SSD. But if they do work over that SGA limit, then there are repercussions, which we'll go into a little later on. There are many different types of work programs that incentivize SSD claimants to work, such as the trial work period, work incentive planning and assistance, or WIPA, and ticket to work. I'm not going to be discussing those because they're very a lot of different rules to those, but just generally you should be aware that there is an SJ limit of working income, and this is based off of someone's gross monthly income, not based off of what their hourly or hourly amount that they're getting, or the number of hours that they work per month or per week. Next slide.
Can I just add something, John?
Yeah,
I'm
sure.
sorry. I didn't know if you were going to go into detail about this, but we get a lot of calls through the Legal Support Center for advocates regarding people losing their benefits due to reaching the SGA level.
Mhm.
And it's really great when they have a coach, the client, and somebody working closely with them. But we've even seen sometimes that a rep payee will do that. I don't know if you're going to go into the 9 times, if they've hit that amount within 9 times. Are you going into that?
No, that's part. Yeah, that's part of the. Yeah, no, I don't really, not really plan on going into that because it's more part of like the trial work and the ticket to work.
So just be aware that if they reach that amount within, it could be 9 months, and it doesn't have to be 9 consecutive months. And it could be somebody who's working for 10 years, and in each month, 1 month each year, they reach that amount. And they're thinking they're okay. They're thinking, okay, second year, they have 1 month. So sometimes it could take about 10 years, especially those people are considered success stories to the Social Security Administration. But unfortunately, they are then cut off. So just keep that in mind if you get clients. It happens a lot of times around the holidays if somebody's working in retail. So I just wanted to throw that out there. I'm sorry, John. I just wanted to get that out there. We do get a lot of calls like that through the Legal Support Center for Advocates.
And we get a lot of calls on our end about that issue as well. So it's definitely an issue, but I didn't really want to go into too much detail on it, but thank you for at least flagging it.
Quick question, John.
Sure.
Does non-blind and statutorily blind refer to people who are legally blind and people who can see, or does that mean something else?
Yeah, no, that would be statutorily, legally blind. Yeah.
Legally blind. Okay. And then second, how would 1619B work if a couple is married, one works, but both have been determined disabled?
Oh, okay. So how would that work? I'd have to, sorry, I'm gonna have to look into that. I'm familiar with 1619B, but I'd have to look in how that plays in. I didn't prepare for that portion of that.
Okay, so what we'll do, Christine, is we're gonna write down that question and then we'll send a follow-up answer after the presentation.
Yeah.
Okay, next question. Is the SGA limit for the month or year?
It's a monthly amount.
A monthly amount. Okay,
Yeah.
great.
Yep.
All right, so I'm gonna move to the next slide.
Okay, so this is regarding to SSI income rules. So generally, the more money a recipient makes, the smaller their SSI check. SSI rules are designed to give the SSI recipient an incentive to work. It doesn't matter whether, same with SSD, it doesn't matter whether it's number of hours or months that they've worked. It's all based off of what they get in their paycheck, and it's gross monthly income. when it's earned income at least. All right, so we can go to the next slide. So there's two ways to calculate what is countable income for SSI. There's earned income, and then there's the way to calculate with unearned income. So the unearned income is there's a $20 general income exclusion plus a dollar for dollar reduction from the unearned income towards the SSI benefits. And then for earned income, there's a $20 general income exclusion as well, unless it was applied towards the unearned income. Plus there's a $65 earned income exclusion. And once you get to that amount, you then divide it by half to get the countable earned income. And the next slide, and you can go to that next slide, shows you kind of an SSI budget example using both SSD and SSIs. So then this situation, Susan receives $420 in SSD and $441 in SSI benefits. She also has a job where she's earning $1,085 gross monthly income. So her unearned income is $420, and we're going to leave that alone, and that'll be her countable unearned income since we have earned income. We'll then apply to her earned income the $20 and the $65 exclusion, which will get us to $1,000, and then divide that in half, which gets us to $500 as countable earned income. We then go to step 3 and add those countable income sources together, which gets us to $920. And then we look at what her federal benefit rate, because even though she's getting $440 for SSI benefits, it's only reduced to that amount because of her receiving SSD. So if she wasn't getting SSD, she'd be qualifying for $840 under SSI. Since $920 is a larger amount than $840, she's entitled to nothing for her SSI benefit. So her total monthly income for that month is just her SSD and her earnings, and she won't get SSI, and she also, because she won't be getting it, she won't be eligible for SSP for that month. All right, next slide. All right, so this is just starting our discussion about the cessation overview. What is cessation? It's basically a suspension of benefits. And for Social Security, they have a look back period of determining when someone is ineligible for benefits and how long how far back they can suspend benefits. So for SSD, it's no more than 4 years, and for SSI, it's no more than 2 years, unless Social Security determines it's fraud or similar fraud.
So John, you're freezing up a little bit. Can you hear us? Looks like we're having some technical difficulty. John, can you hear us?
Yes. Yes.
You're freezing up a little bit.
Oh, okay. Can you hear me now?
We can hear you now.
Okay.
But if we need to, we might have to have you sign in and sign out again.
Oh, okay. All right.
Just so you know, you were freezing a little bit. I'll let you know if you keep freezing.
Okay, thank you.
Yeah.
Not sure if what I said before was heard or you just saw the
It was
person's
not
screen.
heard.
Okay, so what I was just saying was that why are benefits suspended, and it's could be a host of reasons, but these are some of the prime examples are because of a CDR review where it's determined that the claimant has medically improved and is no longer disabled. They're working over SGA, they're over-resourced, they transferred resources, or other determinations for ineligibility. Next slide. So for SSI, a very key point to remember for your clients is that if their benefits are suspended for 12 months or more than 12 months, they will actually, their benefits will be terminated, and they'll have to reapply, which is a big deal for SSI. So you really want to try and get the suspension of benefits handled before that 12-month period is over. In a situation where someone is working over SGA, there are ways to get their benefits reinstated through expedited reinstatement. So the situation would be basically the criteria is basically benefits are stopped because of earning over SGA. They're no longer able to work or perform SGA. They're still disabled due to the same impairments that allowed them to qualify for either SSD or SSI. And they've made a request within 5 years from the month that the benefits stop to be reinstated. And that should allow them to get their benefits reinstated once they can provide that proof to the field office. Next slide. All right. So on overpayment, basically is what it sounds like is the person's been overpaid. They received an amount that was more than what they should have been entitled to for that withhold benefits due to an overpayment. For SSD, it's up to 100% of the full monthly benefit. It's all or nothing basically. And for SSI, it's limited to up to 10% of the full monthly benefit. So in 2022, it was $84. And why do overpayments happen? There's a number of reasons, but these are the main ones. There's either an over income limit, over resource limit, change in marital status, in-kind support and maintenance, which could adjust an SSI benefit. Outside of US for more than 30 days, applies to SSI. Institutionalized for more than 30 days, so either in a nursing home or prison. Non-compliance with work incentive rules, and worker compensation offsets could all kind of impact it could result in an overpayment. All right, next slide. Now, a lot of those things are things that can be reported, and there's things, these are the things that you want to make sure your clients keep up to date with Social Security, their change of address, change in living arrangement, particularly under SSI rules, that's more important. Change in income, if they leave the US for more than 30 days, including trips to Puerto Rico. If the claimant is disabled, they have to also report medical improvement and return to work. If they're earning income or earned income, they need to report that to Social Security so that it can be factored into their benefits. Next slide. So these are just some reporting tips. Claimants are required to report an event, a reportable event, within 10 days after the end of the month in which the event occurred. A tip here is that the claimant should keep a notebook or a file to keep track of their earnings or other wage information, and the date that they reported the event to Social Security, the name of the Social Security rep that they spoke to, just so that they have some track record and history of what they've done on their part. So if Social Security claims that they failed to report something, they at least have the proof, how they submitted it, who they spoke to, when they provided it, to show that they really shouldn't have an overpayment. Next slide.
Quick question, John.
Sure.
If a claimant is hospitalized for more than 30 days and the benefits have stopped, how does one get them reinstated when they return to the community?
They should just be, once they've returned, they should inform Social Security of their status, where they are, if they're out of the hospital, and their benefits should be reinstated if that happens. It really just going either calling Social Security or going down to the field office should be enough for that to be reinstated. Whatever, and provide whatever proof is needed.
Okay. Is there a time frame for how long it will take to get reinstated?
I'm not sure if there's a set timeline on when an event. I mean, it should, if it's reported within that time for within the 10 days of the event occurring, it should hopefully be become effective that following month. I would think. So I think it's should be very soon, but I don't know if there's a specific time frame. I'd have to look into that.
Okay. And that's also Christine, so we can follow up to see if there's a time frame. Okay, another question. If a person on SSDI improves and comes off of SSDI, going back to full-time employment, and then say some years later needs to get back on SSDI due to their condition worsening, will their earnings between those years be added to then increase their monthly SSDI award amount?
Oh, I see. I believe it would. I believe it would be, because you're contributing to your through the taxes, the withholding. So I believe it would impact it. I don't know how much it would be impacted, but I think it would be.
Okay, great. All right, next slide.
All right, so these are what options clients have for dealing with an overpayment, and also for cessation issue. Really, we're dealing with an appeal, but I'll go into appeals more a little later. But I just want to make sure that the waiver and request for lower payments and all that stuff it doesn't deal with a cessation issue. But these are the options for an overpayment. So there's first option that should be, if there's merit to it, is an appealing the overpayment. Second would be a request of a waiver. Third is requesting a lower repayment amount. Fourth is just doing nothing, is always an option, I suppose, but not something that probably is suggested. And then outside of the administrative process, there is the possibility of filing bankruptcy. Obviously, Nassau Suffolk Law Services, we don't provide bankruptcy directly to our clients, so I can't really speak to bankruptcy being an option, but I list it there just so that if you feel like your client needs to, that may be a possibility. I would suggest having them speak to a bankruptcy attorney to figure out if that's even a plausible option on how to deal with the overpayment.
And just to clarify, John, although we don't have a unit dedicated to bankruptcy, we do have private attorneys who do provide bankruptcy services.
Yes, and yeah, sure. Pro bono and VLP can definitely assist in that if you're looking for that. All right, next slide. All right, so the next few slides are just going to go over the types that what information needs to be in these specific types of notices. So for a notice of overpayment, for SSD, there's certain criteria, certain information that has to be in there. First, it has to state the overpayment amount and how and when it occurred, the right to request reconsideration of the overpayment, a right to request waiver of recovery, and the automatic scheduling of a personal conference with the field office if a request for waiver cannot be approved. The request for full immediate refund unless the overpayment can be withheld from the next month's benefit. A proposed adjustment if refund is not received within 30 days and adjustment is available. The availability of a different rate of withholding or an installment payment or cross-program recovery, and the need to notify the field office if any action is going to be taken in response to the notice. So next slide. So for an SSI notice of overpayment, it's a little bit different. Some of the key, the first thing, obviously, oh, sorry. Go back, please. Sorry. Skip that. Okay. Yeah. So we have to, the notice has to state the overpayment amount and how and when it occurred, a monthly accounting of what was paid and what should have been paid out, a request for payment of the full overpayment amount, a 10% proposed adjustment of the SSI benefits, and the month and year when that would start, at least 60 days in the future, the possibility of cross-program recovery, the right to request a reconsideration or waiver of the overpayment, and how to request reconsideration or waiver. If the notices have any types of defects, that could be a reason for appealing the overpayment and could result in stopping Social Security from collecting on the overpayment. So just something to be aware of in case any of that information is not in the notice. That could be an area where you can try and challenge it just from procedural issue. All right, next slide. Okay, so then this next slide is dealing with a notice of planned action. And this is the type of notice that you'd get if you're getting your benefits suspended or reduced. And so it's looking forward. The notice of overpayment is really looking backwards. What happened before? The notice of planned action is what it sounds like, a forward determination of eligibility, and notifying the person of their suspension or reduction of their benefits based on their work history or whatever criteria, whatever is factoring into that. The new amount and the month that will be effective, and must be received at least 10 days before Social Security takes the adverse action. And then the information on how to appeal it, or how to do a payment, and also how to request continuation of benefits. Next slide.
Quick question, John. Is there a time frame, like over 20 years, that would determine if they can still try to get recovery of an overpayment? And what I think she means is there a statute of limitations?
Yeah, I mean, once they've sent the notice of overpayment, if it's within the time frame, if it's, I guess, what I mentioned before, either the 2 or 4 years, or if there was fraud, they can extend that. If as long as it was sent within that time frame, either the appeal was not successful or was never filed, the overpayment stands. And so if the person is, under SSI, because the amounts that they're collecting are so low, $84 at most, it could, if it's a significant amount of overpayment, like $20,000, it's going to take a long time for that overpayment to be paid back. But as long as that overpayment is valid from when it was notified of the claimant, there's no limitation on how long it would take to recover it, as long as it's valid when they issued that notice.
Okay, thank you.
Sure.
Does that answer your question, Christine? Just going to wait to hear back from Christine. Okay. Okay, another question. I haven't heard back from Christine yet, but another question. In a scenario where a disabled adult who is previously receiving SSI but is no longer due to a parent's retirement or death, they are now receiving SSA/SSDI as a disabled child under a parent, but does the SSI resource limit still apply to them?
No, I don't believe it would, because if they're getting it now if they're not under SSI anymore and their benefits are based off of their parents' retirement, or Social Security, either SSI retirement or SSD, then it would be there would be no resource limit issue. I don't believe so.
Okay, and then back to Christine's question on the time frame for overpayment. She said, I'm just wondering if the claimant hasn't heard back anything in years, but still doesn't know the status of an overpayment from the 90s when they used to collect benefits.
Oh, okay. I mean, if it's an overpayment that was issued in the 90s and was being collected on, and you're not sure of how, what its status is, I think you would probably want to speak to the field office, find out what the status is, what's been paid, what's been collected, how much is left. I think it also should be the overpayment should also be reflected in their notices of adjusted planned action whenever they get an adjustment in their benefits. So it also should show up there where you should see a deduction for their SSI benefit. But you may want to talk to the field office to find out what the status of the overpayment is, with if it was paid off, or how much is left on it.
Okay. Yeah, and we can definitely talk. And Christine says she can talk offline to give more details. And we can definitely do that. That's what the Legal Support Center for Advocates is here for, more details and specific situations. So definitely. All right, another question. As a disabled adult child who has Medicaid and now receives Social Security on the parent's account, is that person still eligible for Medicaid?
As long as they fulfill, if they're not, as long as they're not impacted by Medicaid's limits on resources or income, I think they, yeah, I don't think, I think that's the big criteria for that would be the Medicaid program.
Yeah, and I think that's a different
Yeah.
area too, so.
Yeah.
Okay, all right, so you want to go to the next slide?
Yes.
Okay.
So here's example one. Susan Smith, who's 45 years old, has been receiving SSI for 5 years. On February 8th, 2022, she receives a notice of planned action suspending her benefits because of being over the resource limit. Then a few weeks later, on February 25th, 2022, she gets a notice of overpayment and claim that she's been overpaid by about close to $16,000. Again, because of an over resource limit, because she received a personal injury settlement. So the next slide is going to just go over how to deal with both of those situations. First, just going over first on the appeals generally. So appealing would be one of the first steps if you feel like there is some merit to challenging it. You can either request for reconsideration can either be done through forms SSA 561 or through an online appeal form that can be linked into through that link. And appeal is basically, like I said before, you're disputing the fact or amount of the overpayment, or that the suspension should not occur. There is a time limit. So if you, which we'll go into in the next slide, but there is a time limit. So if you pass that time limit to appeal, you have to state a good cause reason why you didn't file the appeal timely. And unlike an appeal, if you on the merits, if you get that denied, you can appeal that to the to an ALJ hearing. If you lose on the good cause determination for a late appeal, you can't appeal that. So if you're stopped at that point, then the appeal process is pretty much over. Next slide. Okay. So for an overpayment appeal, you're going to want to look for the notice of overpayment, and you'll file the request for reconsideration. We would suggest that, or we typically would be filing and requesting a formal conference. The deadline to appeal, request an appeal is 60 days from the date of the notice. You add 5 days for the mailing of the notice, so effectively it's 65 days to appeal a notice. So that's why it's important to look at what the date of the notice is, and why I included it in the previous example, because that date, you got to count the 60 or 65 days from that date. Once the appeal has been filed, an overpayment notice, on an overpayment notice, I should say, Social Security is prevented from collecting on that overpayment until there's a decision. Next slide. And then for a cessation appeal, you're looking for the notice of planned action. And you'll do the same thing, file a request for reconsideration. The difference here, though, is you're going to, we typically will ask for a formal conference and a continuation of the benefits, which is key because you want to make sure your client puts that language in there that they're asking for a continuation of benefits, as long as it's done within the time frame. And so it still has the same deadline for a general appeal of a cessation appeal as a overpayment, 60 days plus 5 for mailing from the date of the notice. But for a continuation of benefits, historically, it's been 10 days plus 5 days for the mailing to get benefit continuation. And benefit continuation is only available through reconsideration and for SSI benefits. Social Security in 2021 issued an emergency message that changed that deadline. Effectively now, until April 29th of next year, you have 65 days from the date of the notice to be able to get those benefits continued. So you don't have to stick to that 10-day or 15-day time period to file the appeal. as long as it's filed within that 65-day or 60-day time period, then they should, the SSI recipient should be able to get their benefits restored and continued during the appeal process, or at least the reconsideration part of the process. And again, that could change after April, but as of right now, that's still the case, and that I believe was put into effect sometime around October of 2021, if I remember correctly. Next slide. All right, scenario 2. You have John Williams, who's an SSI recipient. He's 52 years old. He starts working in March of this year. He earns about he works 10 hours a week. He submits his copies of his pay stubs monthly in person to the field office. The benefits stay the same though for several months. Now in October, he gets a notice of overpayment stating that he's been overpaid by $5,000 because of his earned income that they, for some reason, did not adjust when they received those copies of his pay stubs. So what is a situation, in this type of situation, what can he do? Next slide. So you can't really challenge the merits of the overpayment because he reported it properly, but you could ask for the debt to be forgiven. There's no deadline to follow a waiver request. It can be filed at any time, and while the waiver request is pending, the collection of the overpayment is stopped. There is a thing where you can request, because there's no time limit on when you can request a waiver, you can request a reconsideration and waiver at the same time, though you should be aware that the field office will be probably confused about that and will not deal with the reconsideration and just deal with the waiver. So if you go that route of challenging the overpayment, just be aware you may have to overcome a few more hurdles because the field office will probably most likely not process both requests properly. The form to request a waiver is only on paper. There's no online form. It's form SSA 632. Yeah, so that's the waiver process, and that's again where there's nothing to the facts are the amount of the overpayment is correct. There's no way to truly challenge it. You're just trying to argue that this amount should be forgiven or waived. And then the criteria for that is on the next slide, which we'll go to next. So you're going to have to qualify for a waiver, you're going to have to prove two things. The first thing is without fault. You're basically blameless in the creation of the overpayment, and either one of the other two things, which is defeat the collection of the overpayment would defeat the purpose of the act, causing financial hardship. It's presumed when it's an SSI recipient or a public benefit recipient that would be the case, or you could argue that it's against equity and good conscience. That would be like a situations where it would be unfair to require repayment, or maybe ask the question, did the individual relinquish a valuable right or change their position for the worse? If you can check the box on that criteria, then you have probably a good chance to prevail on a waiver. All right, next slide. And here's some examples of without fault. So failure on the part of a former payee to report change in income or resources. Client was working and dutifully reported wages each month, but reports were not processed by Social Security, which is our example number 2. Retroactive suspension or termination resulting from work activity. Client received SSI benefits while being incarcerated or institutionalized, which were, as long as they reported that would be without fault. Client received inheritance or other financial settlement. All right, next slide. And the procedural steps to request a waiver are: you're going to file the request for waiver, follow up to request that Social Security cease recoupment while the waiver is pending. You should also have a right to a personal conference before the waiver is denied, and also a right to a written decision. And then if the waiver is denied, you have the full appeal rights to be able to go forward with an ALJ hearing. And if that doesn't succeed, then an appeals council, and then ultimately a federal claim. Next slide. There's also what's known as a streamline waiver. So this is in response to the pandemic. If an overpayment accrued between March 1st of 2020 and September 30th, 2020, due to Social Security's deferring of workloads, and that if the notice was sent by December 1st of 2020, there's an assumption that the overpayment is really caused by the agency inaction through the pandemic, and there should not be an overpayment assessed at that point. There has to be some, there has to be no indication of fraud or similar fault or misuse by the repayee. It can be requested over the phone to the local office, and the presumption is without fault and against equity and good conscience, and can be again requested at any time. And same type of waiver requirements for the process. Social Security must send a written decision based off of that request. Next slide. All right. Then, if you're dealing with an overpayment that's less than $1,000, you can request that that overpayment be administratively waived. And as long as there's no indication of fault, which is less of a burden than proving without fault, then you should hopefully be able to prevail on that front. So that's an administrative waiver that can also again be requested at any time. Next slide. So if an appeal doesn't work and your waiver, you don't have the ability to wait to get the amount waived, or you just are not able to prevail on that request, the next option is change in repayment rate. You can request that through filling out Form 634, which is request for change in overpayment recovery rate. You just got to provide a lot of your financial information, such as your income, their expenses, their assets, showing basically that they're not able to pay back the overpayment at the rate that Social Security is currently collecting it. And that again still has the same process of an appeal if that's determined not to be the case. Next slide.
John, quick question. For what time period do you have to show bank statements?
I'm not really clear on what that means. Is it referring to? Oh, okay. For the request for the overpayment recovery rate. I'm not sure if the form spells out specifically. I forget if it does, but I mean, you're looking for, the most recent bank statements. The form I haven't looked at the form in a while, but it may spell out how long it should, how long of a period of bank statements that they are asking for. But reasonably, if it doesn't say anything, I would suggest something like most recent, like 3 to 6 months worth of bank statements, something along those lines.
Thank you.
Okay, and our last thing on repayment rates, if the claimant is receiving Medicare Part D through the low income subsidy, they can get their repayment rate down to $10 a month. And also receipt of any form of Medicaid qualifies for the full LIS. You're not now required to complete Form 634 or even document financial hardship since you qualify for Medicaid. So that's also something to keep in mind if you're at that point and your client has either Medicare Part D, LIS, or Medicaid. That could be very helpful. So I believe that is the end of my presentation, and I don't know if there's any other questions at this point.
Right, thank you so much, John.
Thank you.
And thank you so much for everyone for attending today. I'm going to send a follow-up email, hopefully today, just with the slides again, plus a way to access the recording for anyone who was unable to participate. And we'll also follow up on those questions to Teresa. I think it was Teresa, or excuse me, Christine.
Yeah.
Okay, so thanks so much. If anyone does have any follow-up questions, you can definitely reach out to me, scampo@nsls.legal, and I will forward the questions to John. Once again, the Legal Support Center for Advocates, feel free to give us a call if there's any specific situations that you're having with a client. Our extensions are right there. We have our website, which goes through all of the details of every program that we have, and also lists all of our previous presentations that we've had and legal lessons. And you can follow us on social media as well. We're on Facebook, LinkedIn, Instagram, and sometimes Twitter. We don't know what's going on with Twitter, but well, for now we're on Twitter. All right, so thanks so much, everyone, and have a great day.